Okay, abusia yeba eba be breaking waha edemamo. Former Chief Justice Torkornoo IHS what taking action on acting Chief Justice a friend of Paul Baffoe Bonnie abusia or chess and vetting or the aquaco pimo quarter on pese ebebaso and abusia case no coco pimo court no mameno yes say ne action no ewu ono no court be any jurisdiction say omodeka obi a oye former Chief Justice asem enti no court no judges nature and say Mame Torkornoo your action is dead on arrival as you see a lawyer answer aba ede ho nsem aba beto do abusua omo true sa ne application ne outer abusua you see and former Chief Justice Torkornoo Mame no ono yes okope ne baby da mo be yanko na yenkonkoti ensema lawyer answer ede etu bia subscribe like na share ma afofro so answer into me and kabia ha Ghana politics avenue so madam say
of the concerns of the former Chief Justice at the time. Now the president has taken his decision, so we know what the official government position is, that Gertrude Torkornoo would no longer be the Chief Justice. She's up again fighting, and this time round she's adding two more concerns. One has got to do with benefits as Chief Justice, or if you may want to call it former Chief Justice. Then there's the concern about the swearing in of a new Chief Justice. She wants that process to be put on ice for a bit while the court looks at all of the concerns she's been raising, calling the process unreasonable even in the first place. Well, my guest for today, I call it a table of lawyers now, isn't it? Akuffo is the former director for the Ghana School of Law. He's joining us via Zoom. We'll have former director for legal for the NDC, Abraham Maliba, also join us online. Then in studio, we have lawyer Koesuman, who is the counsel to former President Nana Addo Akufo-Addo. We have Dr. Yaw. He's not the one actually running for the NPP presidency. This is the Afafranto one.
Yes, very right. Very right.
So Dr. Yaw is also joining us. He speaks for now the United Party. It used to be Movement for Change. He speaks for the UP now on economic matters, but obviously has some concerns and takes on the Chief Justice issue. Lawyer Wayo Ganamanti is the 2024 running mate of the Convention People's Party. He's already in Parliament asking Parliament to impeach the president. I wonder why he started that process already. Some say too early in the day, but you say we can't wait. We can't wait enough, isn't it, Council?
Galam says it's very serious. So we cannot wait when we are all extinguished before we begin to do what is right.
Right. So we'll hear a bit more from Council later on the show. But you can be, as I always indicated, a part of the show. Just send us your comments, send us your concerns, and we'll get to read them out. And then, of course, my studio audience will also have their take on all of these matters. Yaw Ansasari, I want to start off with you if you're with us. Good morning to you, and thank you for getting up as early as this to join us here on the show. But let's start off with the tape we've heard from the former Chief Justice. Now she's, back again in the court. You say that she's behaving as though, the position she used to hold is her personal property. I mean, that's how you're describing all of this. But don't you see any basis in all of the points lawyers have stated in this new attempt in court?
Thank you very much, and good morning.
And if you could just sit up for us a bit so we can see your visuals then. Yes.
Yeah.
Right. Okay. That's
You okay now?
Yeah, I think that's better. Yeah.
Okay. Yeah. So sure. Yes. So the matter is now a beating arm being back and forth. She's been running amok, to various fora, ostensibly to seek justice, as if justice, cannot be said in Ghana. Now, this is a matter, that arose from the establishment of a special committee appointed, by the president in consultation with members of the Council of State. And she's trying to draw an analogy between the institution or the judiciary and the chieftaincy institution. Now that she is arrogating nakedly, some powers that she doesn't have, power to nominate who becomes the Chief Justice. That's why yesterday I said that she is behaving as if, the position of Chief Justice is analogous, to the position of a chief, and therefore when the position is vacant, then the person to nominate, must initiate a process of selection, leading up to the nomination. But that is not what, we have here. The institution of chieftaincy, is guaranteed under the Constitution, subject to its customary usage, while the judiciary is a creature of law. So the two are not different at all. Therefore, where the president has established a committee to go into allegations contained in petitions submitted, to the president, who has forwarded it to the Council of State, and then in pursuance of that, a committee is established to go into it. The only instance where one can find any fault is where, for instance, the rules of natural justice, were not observed. But here we are. If any Ghanaian can say that, in this Article 146 CJ removal process, the provisions of the Constitution were not observed, then perhaps, that person might not, have been following, what transpired at the Justice Court Committee. So the point is that we must be able to segregate, the jurisdiction of the High Court, which is what is confusing most people. The High Court has jurisdiction, but we must look carefully at the provisions of Article 140. The jurisdiction of the High Court is subject to the Constitution, and in that regard, the High Court, for instance, does not have jurisdiction to entertain, causes or matters affecting or relating to chieftaincy. If you look at Article 140, Clause 3, the High Court doesn't have jurisdiction, in matters pertaining to treason trial. Now the former Chief Justice is likening the whole thing to a commission of inquiry. If you look at the provision establishing, that's Article 281, establishing a commission of inquiry, the procedure is patently different from the Article 146 Clause 6 procedure. The two are not the same. So the analogy being drawn here is inappropriate, and therefore, in the interest of justice, and in accordance, with the time-honored principle that litigation must come to an end. If the matter is a beating anvil, it means that it has come to an end, and that is why my submission has always been that the office of CJ is not one's personal property. And therefore, it is not something, that was purposely created for former Chief Justice.
Okay, let me do this. The reason why, I may disagree with you that that's the end of it, is because in this new process she's filing, there are two emerging issues that we haven't paid attention to. Her conditions of service, or maybe her severance package, if we should call it as such. And now she's also raising concerns about halting the new either vetting or confirmation process for the new Chief Justice. Are these two aspects grounded in law for you?
On what basis? On what basis? I mean, you see, that's why I'm likening it, to, the institution of chieftaincy. If you were dealing with a chieftaincy matter, I can understand sentiment. We are not dealing with an institution of chieftaincy. We are dealing, with the removal of a Chief Justice pursuant to Article 146, Clause 6. And in Article 146, Clause 6, the person with the most say is the president. And it is the president, the president, the president, the president. There's no reference to the High Court. There's no reference to the rules of law committee as you have, with regard to the the commissions of inquiry that she abetted her mind to yesterday, because there, the procedure and governance, is totally different.
So she's lost all her benefits. Is that what you're saying? She's lost all the benefits?
Pardon?
She's lost all her benefits?
That's another matter.
But she's raising that. She's raising that. Yeah.
It is not all embracing. So let us try, very hard to differentiate between her removal, as CJ and the justice of the the Supreme Court, vis-a-vis, her retiring benefits. The two are not the same.
Okay, but do you feel that she deserves that? Do you believe that she deserves that? Because she stated that in some of the claims.
Yes. But as far as I'm concerned, and personally, I think that it is too harsh, to deprive her, of a retiring award. But the Constitution does not make retiring benefits, as of right. It is subject to the Constitution, and therefore anything that is, subject to the Constitution, must come within the parameters of the Constitution. The President has acted in accordance with the Constitution. Does he have the power to remove with consequential orders? Yes, the President has. And if the President has exercised that power, together, with a consequential, order of denial of retiring benefits, we should be able, to look at it dispassionately to see if what the President did, has the support of the Constitution or is devoid of legality. If it is not devoid of legality, then the fact that she is being denied the retiring benefits is neither here nor there. Therefore, as far as the denial of retiring benefits is concerned, the proper approach is to draw upon one's humility and let common sense speak. It is not a confrontational matter between a former Chief Justice removed by the President, a former Chief Justice denied retiring benefits pursuant to provisions of the Constitution. If the President has the power to remove with attendant consequences, and he does that, it cannot be questioned. If the President doesn't have the power, then it can be questioned. Okay,
Council, I'll come back to you shortly because there's the aspect of the injunction and possibly what Parliament should be doing from next week, because I'm sure that the memo would go to Parliament. The vetting for Justice Baffoe would have to be set in motion. We'll see what this legal process will mean for, the ensuing matters. Lawyer Abraham Amaliba is also on Zoom. I'll come to you shortly. But let me come to Akko in studio because this is not new to you. And you recall at the tail end of President Akufo-Addo's tenure, a petition was sent by lawyer Kukwasari. Yeah, I recall. And the president says, well, all of these claims you are raising has no basis. There's another one now that has gone through, and unfortunately, the former Chief Justice ought to go. She says it's unreasonable looking at, the processes.
Yeah, thank you very much. Good morning to your listeners. The first and foremost point that we have to make is that the exercise being done or conducted by the former Chief Justice, Chief Justice Torkornoo, is not a personal matter. It's a matter that concerns the rule of law. It's a matter that concerns our Constitution, the application, interpretation, and enforcement of it. It's a matter that concerns human rights, the basic natural justice rights that a person has to be accorded. I know my learned senior is likening, her exercise to that of a chieftaincy, but that is completely, with all respect, wrong. She has not mentioned anywhere that this is a chieftaincy matter. The Constitution of our country says that if you have been deprived of your rights, if your rights have been curtailed in any way, shape, or form, the appropriate forum is the courts. And that is what the Chief Justice, Torkornoo, has been engaged in. She's been engaged in the courts. When this matter initially arose, she took it to the Supreme Court. She has been fighting in the Supreme Court. To date, none of those matters in the Supreme Court have been determined.
Really?
None. From the very...
What of the processes that
She sought an injunction. The Supreme Court said that we will not grant the injunction, but we'll determine the matter. And then any consequential actions can be taken after that. That hasn't happened. In fact, I know for a fact, and anyone can apply to the ratio of the Supreme Court to find out, that the Attorney General, who is a defendant in all these Supreme Court matters, hasn't filed a statement of case. They haven't responded. And so it is extremely unfair, extremely unconstitutional, in the manner in which the entire process has been conducted. And if today the Chief Justice is going to the High Court, because now the proceedings are over, she has asked for a copy of the report. And mind you, the Supreme Court has made determinations on this particular matter, i.e., that when the committee process is over, the constitutional injunction of an in-camera proceedings is lifted. What does that mean? It means that every document from the petition, the evidence that is tendered, that was tendered during the process, the reports, every document should be made available.
Do you feel that we've gone past that? Many if you look at the construct of Article 146, everything rises and falls on the president. It's quite a political process rather than law, isn't it?
It is a constitutional process. The president exercises his power subject to the Constitution. That is what Article 58 says. The power that the president is exercising under Article 146 is quasi-judicial, i.e. because he has to make a determination. The second, that's the first one with respect to the prima facie determination. The second aspect is more of an executive function, i.e. the committee makes recommendations and then he has to act on that.
The reason why I'm asking is, for instance, you look at some of the latest claims she's asking for to hold this new process for Justice Baffoe. That's an administrative process, is it? Can the courts really stop that? Because a new appointment has been made by the president.
No. The courts, the Constitution grants you the power, the right to go to court to seek certain orders. One of the orders is a prohibition. If
I'm wondering why or how, and I'll give you the.
No, but
I'll give you the opportunity to land. Just to explain my question, I'm wondering how the Supreme Court will once again enter that whole confrontation with Parliament to tell the Speaker that don't go ahead with your.
She's not in the Supreme Court. First of all, she's not in the Supreme Court.
Yeah, but whichever court, whichever level.
Yes.
I'm wondering how that's going to happen. That you ask the test of our land to order the Parliament of the Republic.
Prohibition not to go.
Yeah,
that's a test of our Constitution.
But is it legally sound?
It is very legally sound. The Constitution says that if your rights have been breached, or if you want to seek a judicial review of a matter that has been taken by administrative body, remember, the Constitution grants you the power to bring decisions taken by administrative bodies that are acting in a quasi-judicial manner to the courts for that to be determined. Now, if the committee has completed its work and the Chief Justice says that this did not stand up to the legal principles, they did not meet the test of stated misbehavior, we need to bring it up for scrutiny. The committee's work needs to be brought up for scrutiny, and that is the only way we can determine whether or not the right thing was done. We cannot sit around the table, in the public domain, have conversations. The president, like everyone else, is subject to the Constitution, and the Constitution grants the citizens the right to go to court, to defend their rights, to defend even the very Constitution itself, to defend the very Constitution itself, the application of it. If there is nothing wrong with what has been done, let the court say so, and then we'll know that this is a judicial precedent. Going forward, this is how we need to treat certain matters.
And that will guide us going forward.
Okay, abusuya we ne ensema ekoso e political highway ne so. Eye lawyer ansa e na yete ne nka se odisa ensem no etudua o cha se eye Chief Justice Torkornoo okwa former Chief Justice okwa na eye Supreme Court Chief Justice no seat no enye traditional seat. Enye ahemfofo seat na maame no ababeje atale na ni ase. Ebeda masesa moje pene kokoti sa ensem wi e de MI aha Ghana Politics Avenue so. Medamase.